Welcome to World Arbitration Update. My name is Jose Antonio Rivas. I am co-founder together with Ian Laird of World Arbitration Update. I am also a professor at Georgetown Law, teaching investment treaty arbitration and public international law. And I am also partner of a boutique law firm called Strategy LLP here in Washington, D.C. and Bogota, doing investment arbitration as well as public international law and international commercial arbitration. World Arbitration Update is a forum that we launched in 2020 with two objectives. One is to update the international community on issues of international commercial arbitration, international investment arbitration, and public international law. That's objective number one. And the other purpose of World Arbitration Update is to decentralize international arbitration. We are aware of incredible centers and places where international arbitration takes place, like Paris and London and New York and Washington, D.C., but those are not the only places where incredible counsel on arbitrators practice. Those places also include Warsaw and Eastern Europe, as well as other places in the globe, including China, where we had our two-day World Arbitration Update last week, as well as places in Latin America, like Bogota, where we'll be ending the World Arbitration Update later this week, and Singapore and Doha, among many others. So it is with great pleasure that we're having our second panel today in Warsaw. And the moderator is someone who has been instrumental to bringing World Arbitration Update to Eastern Europe, Jadranka Jakovic. And I would also like to emphasize that this is a wonderful panel. I've had the pleasure of working or collaborating some capacity already with some of them, including David Pollack, who I admire and respect highly, as well as Sarah Jurjewski, who has been part of World Arbitration Update, as well as the Washington Arbitration Week before. One day, I hope that I'll be able to meet you all in person in Warsaw, hopefully next year. For now, let me quickly introduce Jadranka, who is a civil law and common law trained international arbitration counsel. She has advised both states and investors in investment treaty and commercial arbitration, most notably in cases conducted under the auspices of ICSID. Jadranka previously practiced in Croatia, Italy, Belgium, Brussels, as part of the legal service of the European Commission. Currently, she serves as co-chair of the Young Croatian Arbitration Practitioners and is the immediate past co-chair of the International Dispute Resolution Committee of the New York State Bar Association. She has been recognized as one to watch for dispute resolution by best lawyers, and she's a member, of course, of the World Arbitration Update organizing committees, chairing the first edition of the event in Warsaw. Jadranka, great to have you, and I'm sure this will be a wonderful panel. Please take it away.
Thank you very much, Jose Antonio, for your kind introduction. I will add just a few brief notes and welcome you all, whether you're joining us here in PwC's office in Warsaw or tuning in remotely. It is a pleasure to have you with us, and it is absolutely my distinct privilege to welcome you to the fourth World Arbitration Update, which, as Jose Antonio just mentioned, is the first edition to also encompass Central and Eastern Europe. So we will now move to the second panel of the day and discuss the managing of specialized international arbitration practice. But before we do that, I would also like to extend special thanks to our hosts, PwC, and to sponsors, without which this event would not be possible. So thank you to PwC And thank you to Kubas Kostelkovsky and Baker Hostetler for your support in helping us bring this conference to beautiful city of Warsaw. With that, I would now like to introduce my esteemed panel, starting with, on my left, Sarah Choyecki. Sarah is a New York-based lawyer, formerly registered Swiss lawyer, a founder of specialized solo practice SC Arbitration, which specializes in international commercial and investment arbitration. A University of Geneva graduate and Fordham LLM, Sarah has acted as member of council teams and independent tribunal secretary for cases in the energy, natural resources, shipping, commodities, and construction sectors. Sarah is also a moderator of the tech and law platform ArbTech. To Sarah's left, we have David Pollack. David established his independent arbitration practice in 2005. He's a New York attorney and a former member of the US Treaty Arbitration Team. He's a current member of the exit panel of arbitrators appointed by Slovakia in January 2023 for a third 6-year term. He's also a current member of the panel of arbitrators for international investment disputes of the Beijing Arbitration Commission. His practice is focused on investment treaty matters, serving as both counsel and arbitrator. To David's left, we have Veronica Coron. Veronica is a professor of international business law and arbitration and a co-director of the law track at ASAC Business School in Paris. She is also an affiliated partner at Paragon Advocacy, a boutique law firm in Vienna that specializes in international commercial transactions and dispute resolution, and which was established in September of 2023. Previously, she worked in the arbitration teams of major international law firms in London and Paris. She is admitted to practice law in England and Wales, France, and Hungary. Veronica's practice focuses on international commercial and investment arbitration, primarily involving the CEE region. Additionally, Veronica also serves as an arbitrator. She's a member of the board of the Vienna International Arbitration Center, the president of the Hungarian Arbitration Association, a member of the ICC Commission on Arbitration and ADR, and a co-founder and member of the board of ARB-CEE, an event to which we will all head after we conclude our program here. To Veronica's left, we have Wojciech Sadowski. Dr. Wojciech Sadowski is a partner at Queretius. He focuses on international and trans-border dispute resolution, working as counsel and arbitrator. Wojciech has been extensively involved in advisory work and client representation in matters involving international investment treaties, commercial arbitrations, and litigations before domestic courts, as well as the European Court of Human Rights, the General Court of the EU, and the Court of Justice of the European Union. Before founding Queretius, Wojciech was a Warsaw and London partner at a leading global firm and had almost 20 years of working in top legal brands. Since 2008, Wojciech has been constantly ranked as a leading dispute resolution practitioner by principal directories, including Chambers and Partners, Leading 500, Best Lawyers, and Who's Who International Arbitration. And finally, to Wojciech's left, we have Peter Riznik. Peter is an arbitrator in independent practice based in Vienna, Austria. As a Slovenian national, he has a particular expertise in the Central European and Central Eastern European markets. With extensive experience serving as arbitrator, tribunal secretary, and counsel, Peter has participated in commercial and investment arbitrations conducted under the rules of the ICC, LCIA, VIAC, SCC, Ljubljana Arbitration Center, Finnish Arbitration Institute, and the UNCITRAL arbitration rules. In the past, Peter was active in private practice as a full-time tribunal secretary in an arbitral institution, as well as in UN organizations, including on international commercial law and the law of outer space. Like Veronica, Peter is one of the founders and board member of ARB-CEE. He's also a member of the ICC Commission on Arbitration and ADR and his task force on combating corruption. Peter sits on the European Regional Committee of the Campaign for Greener Arbitrations and is also active in academia and serves as a habilitated lecturer at the University of Maribor in his home country, Slovenia. Peter was also kind to share a fun fact, which I absolutely have to share as well, and that is that as a member of a metal band where he was a drummer, he was kicked out for not being serious enough. And so on that note, dear participants, expect nothing expect anything but a serious discussion. I would now like to give the floor to Sarah to open the discussion and give us a brief overview of the topic. And after that, we will move to a general discussion and leave some 15 to 20 minutes to answer any questions from the audience.
Thank you very much, Veronica, and thank you to the organizers for the warm invitation to this timely event in Warsaw, a city that is so rich in history to this day, and it holds a special place in my heart. This is where my father grew up and my grandparents lived. So it's really a pleasure to be here. Each year I've had the privilege actually to witness how Warsaw has been developing remarkably. And one of the things that I notice every time I come is how much more beautiful it actually is. And I think this is a testimony to the dynamism of this region. And at the same time, Warsaw seems to mirror the rapid pace of change in our world that's driven by technological innovation, the expansion of digital economies, geopolitical tensions, and the energy transition. So in preparing in today's presentations, I tried to find some data and articles to give you on today's panel. And I was struck, unfortunately, by the scarcity of the information that I found. However, as many of you have seen, there's hardly a month that goes by without any news of practice leaders, partners, senior associates from big law firms venturing into solo or boutique practices. And this trend appears to be gathering momentum. And today we're here to explore why this is happening. And I'm very eager to hear directly from our panelists on this phenomenon. But first, I would like to set the stage, highlighting a few key developments that I believe have impacted the rise of specialized arbitration practices. And the first one that I'd like to highlight is digital economies. So we've seen the explosive growth of e-commerce that's fueled, of course, by innovation and entrepreneurship. And that's had reshaped market expectations for efficiency, speed, and customer service, which are the same things that clients can expect from law firms. The influencer economy, too, has revolutionized the way that we market and engage with consumers, turning social media's personalities into figures in consumer decision making. New markets, too, like cryptocurrencies, have emerged, creating a new asset class and challenging the traditional financial systems and mentalities. Of course, this goes together with the surge of new technologies. AI, for instance, holds tremendous potential to transform legal processes, from automating routine tasks to deriving deep insights through data analysis. I mean, this undoubtedly will reshape the way that how lawyers will work and the skills they need. You know, for example, while AI can handle repetitive tasks, law firm associate will be liberated. They'll have more time to focus on areas requiring human judgment, and such as strategy and client relations. Additionally, roles like prompt engineering are emerging, where professionals will design and refine AI interactions to optimize performance and outcomes in legal settings. There's another element, I think, important factor, which is the COVID-19 factor. And this is how I started working independently. And I don't know if it's the reason some other people have done so, but that would not have happened in my case without COVID-19. And the pandemic forced a seismic shift in traditional business model with a swift pivot to remote work, digital interaction, and new consumer behaviors, compelling companies, including law firms, to innovate almost overnight. There's the energy transition topic, and I think that will be discussed later today, where to meet global commitment, regulatory requirements, and consumer expectations, businesses are increasingly investing in renewable energy. I've recently learned that Poland's 2040 energy strategy aims for 3/4 of energy to come from zero-emission sources, including renewables and nuclear power. Of course, there's also the geopolitical tensions, which Poland has been quite very close to the center of. So ongoing conflicts have introduced profound uncertainties in the global business environment, affecting everything from population displacement to trade dynamics, prompting companies to rapidly reevaluate how they operate. And last but not least, I think there's the diversity factor. There's an intensified focus on diversity and inclusion within the corporate world, including law firms and major arbitration institutions that have been recognizing that diverse teams drive innovation, better business outcomes, and meet client expectations more effectively. So the transformation in the business landscape has fundamentally changed how we work, how we travel, how we communicate, also influencing our societal values. The digital economy thrives with innovation and rapid iteration, and a focus on efficiency, speed, and customer service. The rise of digital nomads, for example, and the normalization of working from home reflect a shift towards more flexible work arrangements, a better work-life balance, and evolving expectations from employers. Also, the influence of social media and rapid rise of cryptocurrencies demonstrate how quickly new trend can disrupt established industries. So I believe tremendous opportunities await businesses that can adapt to this new economic landscape. For law firms, including those specializing in international arbitration, there's a pressing need to evolve. International arbitration must not only be affordable and fast, but also relevant and accessible to diverse audiences. This necessitates a rethinking of our roles as lawyers. We must collaborate closely with technologists, now in-house counsel, and other stakeholders to develop new models that respond to these changes. Perhaps part of the solution lies in fostering highly specialized, highly skilled international arbitration practices that can meet these modern demands. So I'm particularly excited about the concluding segment of our panel, which will focus on war stories from the field. I look forward to learning from these experiences I believe they will enrich our understanding of these dynamic challenges and opportunities. Thank you for your attention, and let's have a great discussion.
Thank you, Sarah, for this great and insightful introduction. Now, as we've heard during the introduction of the panel, each one of our speakers here have a unique, whether it's a solo or boutique practice. So I would like to start with David. David, you have a very interesting background. You practice both at Big Law and also with a treaty arbitration team of the U.S. Department of State before you set out your own practice as a counsel and an arbitrator. Can you share with us what inspired you to start your own shop, and how did you decide to start this specific type of practice?
Thank you, Veronica, and thank you, Sarah. I also just want to say thank you and congratulations to Jose Antonio before I respond for putting together what has been a pretty impressive global program over the last few years. So thank you, Jose Antonio, and for inviting me to the panel. But to your question, I think we've seen that the proliferation of boutique or solo practices of late take a number of forms, a variety of forms, if you will. And even this panel before the audience reflects that diversity of types of practice. I think we have people who operate in a boutique or solo format that serve as counsel and tribunal secretary, work pretty much solo or with big law or regional powerhouse teams and serve as arbitrator. We have others who work solely as arbitrator and left, it seems, a larger law firm in order to benefit from the advantages of working alone as an arbitrator and relatively conflict-free. And others on the panel are practicing across multiple jurisdictions with reasonably well-sized teams, which might even mirror the size of teams in some big law arbitration departments. And then we also see a variety of firms that have essentially spun off from big law arbitration teams. For example, GBS in Paris, or more recently, Wordstone in Paris, spun off from Decker. My route to practicing independently has, as was mentioned earlier, started nearly 20 years ago and wasn't COVID driven, although it was ultimately COVID influenced and made more, let's say, normalized, because more people were practicing in an independent way. But I had worked for a number of years, first at the Department of Justice in New York, in the US, as a trial attorney, and then at a big Wall Street law firm, followed by what was a wonderful launching pad into what I'm doing now, a stint of about 4 or 5 years at the US State Department Office of the Legal Advisor. And the US State Department handles all investment treaty matters in-house. Unlike almost all other countries, it does not hire outside lawyers to assist in the defense of the cases. So the State Department had assembled a team of lawyers. Most of us had come from either big New York law firms or big Washington, D.C. law firms. And we had an excellent team and great success, and I enjoyed that work tremendously. But to, let's say, put it shortly, my wife, who's an honorary Polish citizen, originally from Belgrade, persuaded me to take 3 to 6 months off from that job and come enjoy the many pleasures of Central and Eastern Europe, which I acceded to do. And that is, let's say, almost 19, 20 years ago, 3 kids and dozens and dozens of cases behind me. So it's been a wonderful and enjoyable ride, sometimes terribly exhausting, but always exhilarating. But I should say that when I started out, I didn't really have the vision for my practice that has materialized, which I should probably be grateful for, because at the time of starting out, I thought, well, I've got some skills and experience in a field that is blossoming from working on some of the early, most significant treaty arbitration cases under the North American Free Trade Agreement defending the US. And I figured that those kinds of cases were becoming more commonplace, particularly in Central and Eastern Europe, and that maybe there would be some existing teams who have cases or governments that would be interested in having me in, let's say, a consulting role for some limited capacity engagement in assisting in those cases. But thankfully, about a month after I was into my hiatus, encouraged by my wife, I was invited to join and lead the defense of a very significant investment treaty claim against Poland. And the local law firm, SK&S, who was represented here earlier, was incredibly gracious in welcoming me as a New York attorney to that team and integrating me into their work. And that case lasted maybe a couple of years and followed on to several other very attractive engagements, mainly in treaty arbitration matters, sometimes collaborating with the SK&S law firm, but also then branching out to other state representations and other private party representations and commercial arbitrations. So much to my pleasure, rather than doing a few consulting gigs here and there, I was basically thrown into often running or taking a lead role in a hearing and in drafting pleadings, and sometimes working with governments alone in defending big treaty arbitration cases. And that's essentially how I ended up doing what I'm doing and where I am now. So I guess I'll leave it at that for the next question.
Thank you, David. I'll just add, those are not my words, but someone very recently told me that behind everyone's story as to how he or she got into arbitration, there is a law story. And this just confirms that that's indeed true. I'll invite our other panelists if there are any comments or follow-up remarks on this question. No love stories, I'm afraid. All right. Well, then why don't we move to the next topic? As David mentioned, over the past few years, we've seen, and we're increasingly seeing a lot of spin-offs, and there seems to be an increasing trend in forming specialized arbitration practices, or so-called boutiques. So, Veronica, is this really a trend? And if so, what do you think is the driving force behind it? Are specialized arbitration shops in the future of arbitration practice?
Thank you very much, Veronica. And let me also start by thanking very warmly Jose Antonio, who I hope to be able to meet very soon, and Jadranka for the invitation, and in particular, again, Jadranka for bringing World Arbitration Update to Central Eastern Europe. I think it's fantastic to put this region on the map because there is a lot of talent, there's a lot of experience, a lot of cases to share with the world. So much appreciated as a Hungarian national. And yes, I think we've heard from Sarah and David a lot of interesting things that I would just echo, really. I think there is a trend. I suggest a few ideas that I have as to what might be driving this trend and in what direction. But I think I'd love to hear from all of you to see whether you agree or disagree. Before coming here, I did a quick search on the Global Arbitration Review's website. And indeed, with the term boutique, I was very surprised how many hits I got even just in the past few years. I echo that there is a trend for boutiques, and that doesn't only concern the traditional arbitration hubs, Paris and London, but stretches over to Warsaw, Vienna, Amsterdam, Madrid, Stockholm, Geneva, Zurich in Europe. Then, as we heard, Washington, New York, Toronto, Singapore, etc., in the Middle East. So it is definitely a global trend. We also see a lot of articles on established boutiques growing further, achieving success both in terms of team growth and in terms of victory for their clients on important cases that make it to the global arbitration reviews, which I think is fantastic. And then again, like we heard, the setting up of solo practitioners to act as counsel and arbitrator, or increasingly as arbitrator, with also the appearance of specialized arbitration chambers for arbitrators to work together. Now, what drives this trend? A few ideas without any order of priority, and I obviously agree with the many points that Sarah already mentioned, that it's COVID and the different way in which we work, digital nomads that I think many of us, and you of course on the panel that we belong to, digital economies, new markets, new technologies. I still think it's very important as a starting point to know and to remind ourselves that we currently, at least, we still live in a free globalized world with the global economy, with increasing threats to free trade and global investment, which I hope will not materialize. For now, they are driving disputes, but let's hope that the world economy stays as open as it is and will continue to grow, because of course the more business activity there is, the more disputes necessarily, and therefore also the more cases to work on for lawyers across the globe. On top of that, I think there are two trends that I see, at least in Paris, when it comes to boutique firms, one coming from clients and the other coming from lawyers themselves. We have starting out with lawyers who are proposing boutique law firm services, so these specialized services to clients, and that's conflicts. So that would be one of the big buzzwords. Obviously, conflicts are very important, have to be taken incredibly seriously, because it's the individual's reputation at stake, but it's also the reputation of arbitration as a legitimate and reliable method of dispute resolution, and that there's no compromises there, which then drives obviously many partners in large firms if they want to sit as arbitrator outside of the firm, or even if they want to take on counsel work, because there may be conflicts with the transactional side of the firm. There have also been conflicts in terms of the type of cases that lawyers have been wanting to do. I think we've seen a lot with ESG related disputes. There have been quite a few boutiques that sprung up because lawyers founding those boutiques said, well, we think there is a huge crisis going on, and as lawyers, we need to take action, and the right thing to do is to set up a specialized ESG climate action law firm. We've seen something similar with the unfortunate recent escalation of the conflict between Ukraine and Russia, where certain firms declined to act for sanctioned Russian parties, and others then said, well, that's a niche that we want to go into. So we're setting up specialized boutiques able to take that work. So that also has, I think, led and fueled boutique movements. Adding to that, of course, cost, being able to offer different, perhaps lower cost proposals to clients with potentially more flexible payment terms is something that many lawyers in big firms have been hoping to do. What I think is also the case in London, Paris, with some of the traditional big firms, is that litigation arbitration partners obviously work a lot and bring in a lot of work and nice turnover, but it might not be enough when compared to the transactional side of the firms. There's an increased pressure for bringing in more and more work and a higher and higher turnover, which may just not be possible beyond a certain stage in arbitration. It's not as lucrative, and the sums aren't as big. I mean, they're big, but they're not as big, I understand, as in M&A and private equity and elsewhere. So there too, there's an incentive to go boutique and to have less pressure and more flexibility when it comes to pricing. And then last but not least, I think surprisingly, there are many entrepreneurs amongst the lawyers who love the work they do, and they also want to do that as an entrepreneur, tailor the services as best as possible to the particular needs of the client, work on only the type of cases for those types of clients that they believe in, that they do best. And so I think that's at least another element I've seen. Very briefly on the client side, I think the buzzword is cost, cost, cost. So again, it's been interesting to see post-financial crisis, but in particular post-COVID, or at least in France, more and more, even big companies, they keep a lot of the legal work in-house. They only outsource when necessary, and when they do outsource, I think they really do pay attention to what is being billed to them and how. And there is there's a need to really justify what we do and what is being billed and who's working on the case and how that comes together. And again, with the cost structure and the payment terms, perhaps being more flexible. But secondly, it's the availability, I think, of partners. Again, I think many companies realize that they might be able to get a more personalized service, or at least a closer attention, more partner exposure and direct client contact when they work with boutiques. Teams tend to also be more senior heavy, so you don't have the army of junior lawyers and support staff, which in some cases is necessary, but in many others maybe it isn't, and it's much better to work with an experienced senior heavy team that comes after 10 years or more from big law to join forces with a boutique to make sure that the advice is really advice from experts with specialist knowledge, tailor-made, and there's good availability and good communication with the client, between the lawyers and the clients. I think I've got more, but I leave it here for discussion, and I'm interested in everyone else's views as well. Thank you. Thank you, Veronica. Do we have any follow-up remarks?
Thanks, Veronica, and I would like to join in congratulations to you, Veronica and Jose Antonio, for putting together this discussion and then this series of World Arbitration Update seminars around the world. I would like to do add to Veronica's comments two things. I agree with everything that Veronica has said, but I also would like to offer my own perspective, which is that I think there are two major trends which drive the appearance of more and more solo practitioners and arbitration boutiques. The first trend is driven by lawyers, the other trend is driven by the market. What I mean by the trend driven by lawyers is that, of course, conflicts are important, but not only conflicts related to clients, but also internal conflicts within big international teams where those lawyers are based. Sometimes it's, you know, the Game of Thrones, things you even win or you leave, your fight for power within the team. Sometimes, and I refer here to the trend which I'm seeing in the United States, where the billing rates for the top partners at major firms have gone up to $2,500 per hour or more. So with the scarcity of clients being willing and able to pay these types of rates for international arbitration disputes, also with the proliferation of the know-how as to how to handle arbitration matters, and that know-how being available all around the globe, it's becoming increasingly difficult for the partners in big teams, big brands in international practices to achieve the desired levels of profitability. And then people also have their own personal decisions as to why they want to leave big law. Some people face glass ceilings. Sometimes people come from one jurisdiction to one of the arbitration hubs, but they don't really belong there because they were raised somewhere else, and it's difficult to build a client base there. So they prefer to go back to their home jurisdiction and apply what they've learned in Paris, London, or DC, and to sell this to their local clients that they have, that they can understand better and communicate with better. So that's the lawyer's trend. Now, the market's trend is a little bit the flip side of the same coin. And what Jose Antonio said at the beginning about the diversity and decentralization of arbitration is very much a thing. The economy has changed, and also in the legal market. It's no longer the thing that the big beats the small, but it's the quick that beats the slow. And it's much easier now than before to have access to the same or comparable level of IT, technology, support, artificial intelligence. Even when you operate a very small team, even if you operate from a low-cost jurisdiction, even if you operate managing a decentralized team, to provide very similar quality of work than if you were based physically in Paris or London or New York. And you will have people from all over the world already knowing how to do things, who want and probably prefer sometimes to go back and work from other places. So I think what we have been seeing recently is the proliferation of boutiques, which are based in other parts of the world outside those major centers. And maybe also commenting on what David said before about what drove people to establish their own boutiques. My own story is that I was a partner for probably 10 years with a global legal brand. But I had a situation very similar to, I once read a story as to how Steve Jobs recruited his CFO from PepsiCo, who helped to grow Apple. And the guy had to give up his position at PepsiCo, where he was earning a lot of money, to go with a relatively unknown Steve Jobs in order to set up something which would have taken off, but not necessarily. And Jobs convinced the guy by saying, "Do you want to keep selling sugared carbonated water to kids for the rest of your life?" And my translation of this question was whether I wanted to be in the big law for the rest of my life, doing comparable stuff for the same types of clients, or do I want to venture and try to do something else? So we decided to set up a boutique that would be specialized on dispute resolution, we do dispute resolution only with focus on international disputes and with particular focus on Central and Eastern Europe. And to do that, we noticed that there are lots of Central and Eastern European who have some experience in those principal arbitration hubs like Paris or London or New York, but who prefer to work from the region. They have the necessary experience, but they communicate much better with the clients in this part of the world. And surprisingly, there hasn't been a similar boutique before. So the way we looked at the market was that we want to look at the CE as one market. It's of course composed of maybe 15, maybe 20 different jurisdictions, but those markets are very small. And the supply of arbitration cases from those markets is not high, and the clients on this market don't want to pay the New York or Paris or London rates. So what we can offer is that they have our full attention and our understanding of the local culture, local language, and local law, and we can work for them on rates which are acceptable to the region. So there, we identified a niche on this particular regional market that we want to fill in. And I would think that there are very similar considerations in other parts of the world that I'm not an expert in, but I'm sure that all around the globe, there will be similarly minded lawyers who may have similar opportunities, and maybe some of them want to pursue these opportunities. So this is my take on the problem.
Thank you, Wojciech. This is a perfect introduction to our next topic, for which I will also hand the floor back to you. So please feel free to answer any or part of my question. But I'm curious to hear, what does it take to start a specialized arbitration practice in this market? And if you could share also some challenges that you face, as well as which factors play a critical role in your day-to-day business.
Thanks, Veronica. I mean, there are lots of aspects, and I could talk for hours about this. Let me just say that I think one of the most important challenges, and also one of the most important points that need to be taken into consideration if someone wants to set up its own practice, is to answer the question, why am I doing this? And before starting Precious, I read a lot of books about business, not necessarily with the legal business. And one thing stuck with me is that if you want to set up a business, you cannot do this for money. I mean, if you do things correctly, if you have luck, then money will come as a matter of fact. You cannot start a business just for money, because you will have ups and downs, you will have a lot of difficult moments. And in order to persevere, in order to overcome those difficulties, you need to really love what you do, and you really need to see some greater good or deeper sense in what you are doing, because that will give you the force that will allow you to go forward. You also shouldn't do this only because you happen to have a client and you want to run with a case from the law firm where you currently work with and take the client with you, because and I've seen this over and over again, there are people who end those cases settle, or the clients go away, and then they are out there without any business case and without any clue what to do next. So in order to not to be in that position, I think one needs to be clear about the positioning and what they want to achieve in the market. And our positioning, for example, is that we are purely dispute resolution firm, and we focus on this region. And having this clear focus allows us first to know what we want to focus on and be best at, and more importantly, what we don't want to do. And there are lots of types of works that we won't do, we will rather send them out. But that positioning also allows us to very clearly understand who our competitors are on the market, and even more importantly, who our friends on the market are, because you cannot win doing business alone. And when we determine who our competitors are, there are essentially three groups of entities. These are either large national law firms who have their own international arbitration teams, or they are regional or international legal brands present in Central Eastern Europe on our jurisdictions, or these are international arbitration boutiques based somewhere else. But with regard to each of these three categories, we can easily explain to the client why we could be better, why we can bring value that any of these firms cannot bring. But we also know that we can, in principle, collaborate with anyone else on the market. And an important part of our business comes from other firms, be it law firms or consulting firms, and especially law firms who don't have themselves international arbitration practice, because we are safe for that. We are not going to run away with their clients because we are only interested in doing what we do, and we want to do this best. And we communicate this clearly, and we refer or work to those firms, and sometimes they reciprocate. So positioning is key. It's one of the key issues when starting a new business. When it comes to challenges or some anecdotes, I found it particularly and surprisingly difficult to find reliable and tailor-made IT support. And I was really surprised by this because I thought it's just a plug and play with the supply which there appears to exist on the market. But then you start to discuss with the providers, and then you realize that there are problems, because some of the solutions that most people in this room are familiar with, for example, concerning document management, are solutions which are designed and implemented largely for large enterprises. And when you want to do the same in a boutique, then surprisingly, you find out that the implementation costs of software may be something like 50k euro, which just makes no sense for you, especially if you run operations in Eastern Europe. Or there you have some solutions which are cloud-based. Now you need to decide whether you want to have control over your files, or whether you're okay with a vendor and his cloud. And that may mean that you will have no control over the documents or files of your client. You need to be aware and conscious whether this is a risk that you want to accept. You may find easily vendors who are, I would say, one-trick pony people who will be familiar with particular type of a solution, but they will not be able to provide you with a very comprehensive advice as to how you want to run your IT system. Or you will have people who are very good at IT, but very poor in communicating in commercial terms what they offer and what you need and what implications it has. So it was, at least in my case, one of the greatest challenges.
Very interesting. Thank you, Wojciech, for sharing this interesting remarks. Any follow-up?
I'm just following up on what Wojciech said in the IT. I am now an arbitrator in independent practice. So obviously I am not investing 50,000 euros into anything. I did used to work for a specialized arbitration practice. There, with IT, when we started, and let me say first, that was in Austria. In Austria, law firms are notoriously using, let's say, software for documents, for document management, for case management that looks like it just came out from the 1990s. That would be nice. So it doesn't matter how it looks like. It's just like really, really awful. So all of the law firms in Austria use that. Some of them also use other stuff. So honestly, I spent more than a month of my time as counsel putting together, probably more, dealing with IT stuff to set up the system with the firm. And that, of course, as Wojciech said, you have quite some issues on one side with external IT because they don't really know what you want, but so you have to really have internal people to deal with this. And of course, if you're working for big law, that you can have an IT department that is doing these things. With a smaller practice, you have already one person dealing with the IT system for 2 months. That's already a couple of billable hours. It's it's not great. What I thought maybe if I think about a couple of more challenges, and again, as said, I am an arbitrator in independent practice. So let's say my challenges are different. But if I think about potentially, specialized arbitration practices challenges, I identified 3 issues which would maybe be client acquisition, which I think can be quite different than in big law firms. Often in big law, you will get a case from the other teams at the same firm. You get a case with your transaction colleagues and maybe messed up or not, and you will be. That's obviously going to be an easy case to get. That does not work in a boutique. You have to be on your toes. You have to be, and of course, you have to present yourself in your firm, and in particular, your employees. I mean, I see very good practices also from my colleagues over here on the panel. How their law firms are promoting, let's say, also their more junior colleagues on LinkedIn. They're writing things, they're talking. But of course, again, from a bit of an arbitrator point of view, we had last year at the Vienna Arbitration Days, we did a bit of a survey on how people appoint arbitrators. So, like, basically, if we say, how does an arbitrator get a case? And by far, most participants said that it is through, basically through a personal connection or through a recommendation. So that's, in the end, people were looking at lists only to confirm what they have already discussed with someone. I often get asked by friends, colleagues from, let's say, the more Western parts of Europe, do I know someone in Poland that would do this? Do I know someone in Central Eastern Europe or not even Central Eastern Europe, but do I know someone that would be a good arbitrator for this kind of a case? And usually there are cases around involving at least a party from the region. So that, I think, is very important. So of course, if you come to a conference like this, you say a couple of smart things like my colleagues here, then I guess people will see, okay, this person knows what they're talking about, but in any case, all of this personal connection, I think, really matters. And of course, for a law firm, I think it's fairly similar. Of course, you can have a nice website, but that's not enough. If I may say, mention the unpopular topic of financial stability. Obviously in a big system, you can cross-finance things. In a smaller system, you cannot. And especially for an arbitrator, that is a bit tricky. If you just decide, okay, I'm going to now sit as arbitrator, like yours truly, perhaps foolishly not, foolishly did. We get paid at the end of the case. So, I mean, I know now that I am getting 0 income until the end of the year. But of course, you have to organize yourself a bit differently than if you are, sending out invoices on a quarterly basis or even a monthly basis. What else could I say? Well, maybe, infrastructure. I think we've already mentioned this. But I think it is even more important to be running your cases, and I'm talking, be it counsel or arbitrator. It requires excellent project management skills, and especially as counsel, running a team of people working like a party representatives. I don't know too many people that have done proper training in project management. My wife does that for a living. She's not a lawyer, and I see how they deal with projects. And I mean, we see with quite some firms, like let's say quite some firms, things are forgotten. Things are, like, oh my God, we forgot this, we forgot that. So of course, and if you have a small team, of course, it's maybe easier to manage, but it's a little bit less forgiving. There's no 30 associates waiting for you to just throw them something on Friday afternoon, you know, like you have to be, and of course you have to respect your employees, which doesn't mean that you don't have to respect the employees when they're big. So, I think, you know, how all of this applies to an arbitrator and independent practice. I need way less infrastructure. So, I mean, I don't need all of the filings have been electronic, like also before already, but I don't even have to print things. I do miss my associates. I really miss associates. It's not just because it's, you know, being on your own is a little bit lonely. Also, in, let's say, in more in preparing, I was now writing a book chapter. You know, I do not have anyone to do any research for me. I have to do all the research from the very, like, that's, you know, I would ask someone usually that is 15 years younger than me or 10 years younger than me. I have to do everything myself, which obviously takes a long time. So you then have to kind of think of things differently. And of course, you know, in a firm, you would, I think also partners, you kind of take a bit of a more hands-on approach, I think, in a smaller boutique. One thing maybe, so of course I don't have a secretary as an arbitrator. That's usually is not a problem, but it has happened to me that, for example, once a party representative called me on my mobile phone and asked me how to upload documents to the ICC Case Connect. You know, I'm kind of, there's a partner at, let's say, you know what, so not a boutique, it was a bigger firm, you know, and I mean, these kind of things, of course, don't happen if you have someone to pick up your phone, you know. So like, and I don't see who's calling. I just like pick up and then, oh, hello, you know, how do we do this? So of course, these are the kind of things that maybe I do miss sometimes. But yeah, in general, less conflicts, more freedom, you know.
Thank you, Peter. As a follow-up to your comments, you briefly touched upon the issue of securing new work, which, as we all know, can be challenging. So you mentioned some of the challenges there, but can you also mention some advantages of looking for, you know, securing new work as a solo practitioner? Well, from your perspective,
Well,
as an arbitrator,
it's much easier. I have to say, it is much easier. The second I left the law firm, I immediately got I started getting requests for, let's say, cases that were 10 times bigger than I used to get before when I was still in the firm. So it's a perception thing, but of course also, of course it's a thing of conflict for sure, and not even, you know, in any case, I decided to do to become a, you know, an arbitrator in independent practice because I wanted to sit as arbitrator. I mean, I really, that had been something that I had started out as being tribunal secretary full time, and then, you know, it's something that I've been doing for a while. With any firm, you know, you create conflicts, and even in Central Eastern Europe around here, you know, I had to, at least 3 times a year, I had to decline cases working for a boutique firm, you know, because it was a disputes boutique, or at least declare things, or maybe, you know, there would be something that I don't think it would be a conflict, but I rather don't accept it because, you know, maybe my colleagues will then have a problem in their case where they're sitting as counsel because someone might bring it up there and they just don't want that, and the client doesn't want that, so that Peter can sit as an arbitrator in another case, you know. So that I have to say, and I was just talking to someone yesterday, and I mentioned all of this, and then I remember it was with it was 2 colleagues from the same firm, and the other one started freaking out like that's, you know, I'm trying to get his colleague to quit their job, you know, because it is quite completely different once you leave the firm. But yeah, if you want to sit as arbitrator.
thank you. Any follow-up remarks on securing new business as counsel, maybe?
Yes, just a few thoughts, if I may. I do think it is generally difficult to secure clients for arbitration work because there are few repeat clients, right? It's not transactional work. Most clients will want to avoid disputes, and I think our first and foremost duty is to help them avoid disputes, and if disputes are there, help them settle the disputes rather than go through to the end. And few clients will have a large and constant inflow of new disputes work. And if they do, quite a few of those cases will be, large scale, multi-million, billion euro cases, which I think CFOs more often than not like to have entrusted to a big brand just to be safe. If anything goes wrong, at the very least, both legal counsel and CFO can say, well, we've looked at Chambers and Legal 500, and we've given the case to this and this well-established US Magic Circle or other firm. Now, having said that, I think if you do manage to secure one or two clients, that's great, because if the dispute doesn't settle, it means a solid workload and hopefully income for 2-3 years as counsel. You can organize your work, and you can build on a few clients and then expand your client base and perhaps your team as well, but it's not easy. And I think it's particularly, and correct me if you disagree, difficult in Central Eastern Europe because we have a tendency, I think that exists also in the West compared to the US firms, but I think in Central Eastern Europe it's even stronger to think that whoever sits west from Vienna is necessarily a better lawyer, a smarter lawyer, much more able to do the work. I think the trend is changing, and RFC and events such as this one are hopefully contributing towards changing this trend. But I do think that clients will be more likely to entrust the same case to a Viennese lawyer than to a Hungarian lawyer, even if the experience of the Hungarian lawyer is better, just because we think certainly the Viennese person must have had a better and different training. And if you talk London or New York, that's grass is greener on that end. And entrusting case to our own nationals or cross-referring within the region, I think, is incredibly rare, and it's up to us to make that happen, to build those connections and to show clients and to also show each other that we can appoint Eastern European arbitrators in cases. We don't have to go with the same Swiss and German guy again and again. We can refer work to each other. We don't have to work with the same Paris-based whichever firm, because it's because that's how I think the cake will be bigger for all of us. Perhaps just one last point on research assistants and all the work and how you manage, and I'm not going to get into a lot of IT detail because we've heard that, but I again, you might disagree, but I do think that one of the important propositions of a boutique is focused attention to a case at a senior level of the team, which cannot mean that you outsource research and the factual review to juniors or to computers. I think it is that there's no way around it. In order to feel a case, to get to breathe and live the case and come up with ideas, come up with a strategy, there's no way around it. You just have to get absorbed in the client's business, in the story, in the facts, so that you can then pull the evidence, you can connect the dots, you know where to look for dots, and I think that's what makes a good lawyer, and that's what makes teams win or lose cases, and that necessarily means that senior lawyers, partners managing the case, they have to know the facts, they have to have seen everything, and not just what lawyers perhaps less experienced had pre-selected for them. I think that's the proposition of big law, and it often works, but it also often doesn't work. And if we want to propose something different, I'm very very strict on that. I think there's no such task that is not important enough for a senior lawyer to take a very close look at. Thank you, Veronica. I believe Wojciech, you had to.
If I may, I have a couple of points on sourcing work. The first point is that if you start practicing international arbitration at the boutique and you previously worked at big law, you may tend to look at things the same way that you were used to when you were in big law. And the first thing is that things are not going to be the same for you, because you will not be able to work immediately for all the same types of clients. There will be clients who will simply not work with a boutique because they have policies, because they only work with law firms that are on panels, because they require a law firm that they work with to be ranked or to have, I don't know, 3, 5, 7 years of existence on the market and so forth. So you need to be realistic with whom you can work. Now, there are 3 major ways to source business in international arbitration. The first is to marry a billionaire. Second is to capitalize on your existing connections, including with clients. And the third and the hardest is to do your homework and expand your potential client base. And as Veronica said, it's difficult because there are few recurring clients, and those recurring clients are typically lawyered up. Those will be, I don't know, some big internationals, especially energy companies, construction companies, because in construction disputes is just the second leg of business. But you need to approach things systematically, and I would think that the most important aspect there is to approach the client's perspective as to what is the actual value that the lawyer in the boutique can bring to that client that nobody else can bring on the market. And that requires, as I said before, positioning. That requires a boutique to know exactly what its role and place on the market is, geographically, sector-wise, in terms of experience, in terms of the types of cases. Then to think about creation of value for the client, and then that value may consist in different things. It may be price, but it will be also expertise, or it may be the familiarity with particular types of cases, or the ability to work with the best in the market. And then after you can, the types of clients or the types of cases that you can actually sell something to the client, then you start selling. And it's a long process, and a lot of it depends on pure luck. I disagree with Veronica with regard to the approach that clients tend to believe that there are better lawyers in the West. I think that's at least not true in Poland, as we here have quite a mature arbitration community and arbitration markets. I would think indicatively we have over 100 international arbitration professionals who have seen international arbitration cases. And I would find it quite unusual for a client in Poland to outsource international arbitration work to a Western-based firm, especially if that dispute concerns this market. If the dispute is governed by a different law, that's a different story, but also there, I'm familiar with lots of cases where the Polish law firm handled the case and just retained the local counsel for the issue specific to that local law. So these are my comments on this.
David?
I could just add something briefly to the notion of what advantages might there be for people operating as solos or boutiques and they're in the region. And these echo some of the points that have been made, but as Wojciech pointed out, with big law partners in New York, sometimes charging out in excess of $2,000 an hour, there's obviously a lot of room between that charge out rate and making a very attractive living, doing very interesting work in a boutique or solo kind of arrangement. But further to that, and probably even more importantly than the rate, because I think if the case is big enough and important enough, sometimes the rate itself isn't going to deter a client from engaging a particular lawyer. But to Veronica's point, I think it's an excellent one that if you are a senior solo or boutique practitioner, and you go pitch to a client and you're competing with a number of big law teams, it's almost certainly the case that they're going to throw a lot of bodies at the case from the big law team. Many times those people have although they're often very impressively credentialed and talented people, they're young people and they're a little bit inexperienced to handle some of these kinds of cases without a heavy hand from the senior partnership. in my experience over now 20 years, it is frequent that I go to a hearing, having done the case from A to Z, meaning caption on the front page, signature block on the end page, all the documents on my own, and the big law partner on the other side has been fed maybe many memos or coached by a bunch of juniors as to what the file's about, and they just don't have the degree of familiarity with all the details that is really vital to succeeding in the case and presenting it in the most compelling way. And so therein lies, I think, a fantastic opportunity for people who are operating outside of that kind of it's a big firm structure.
Thank you, David. Now, I realize this panel is standing between you and lunch, and so we won't take much longer. And we do want to also leave a couple of minutes for Q&A. But before doing that, I would like to invite each panelist to briefly share, maybe in a minute or two, one of their war stories, starting with Sarah.
Oh my.
I didn't think I would start.
Okay, well, I'll pass.
Okay. Okay. Well, I guess in thinking about some of the comments that we might cover in this session, I remembered reflecting back to the early days of my career when I was a trial attorney at the U.S. Department of Justice in New York. And one of my colleagues was a gentleman who was soon to retire, Bernie Mendelow, and he knew that I got a job at a big Wall Street law firm, Milbank, which I see as we have a retired partner from Milbank here in the audience. And, I was thrilled to land that position. And as I was leaving, Bernie came over and shook my hand and gave me one line of advice and said, just remember, they put on their pants one leg at a time, just like the rest of us. And why that is actually significant, kind of reflecting on my practices, essentially, be not afraid. If you want to enter into a boutique or solo practice, you have to be willing and be open to opportunity, be flexible, not have an ego, but ensure that the partners that you team with and collaborate with, and obviously a client, are able to shine, exponentially, even if that means sometimes, stepping aside, even though you may have done most of the heavy lifting in preparing a presentation. But in that regard, I'll just say, after some of those early cases I did here in Poland with the SK&S law firm, I had a wonderful opportunity to meet some of the officials at the Ministry of Finance in Bratislava for the Slovak government. And there were a group of young people working in the ministry who were eager to see whether they could arrange to do things in a way different than they had been doing previously in terms of defending their cases. They had a very talented, eager to learn, reasonably young team. And I was very grateful that at least one of those people had, actually two of them had obtained their law degree in the United States. So I think they had a familiarity as to what I might be able to bring and offer in defending their cases. So I'm incredibly grateful that they gave me their trust in competition against several big law teams and other local teams to take on a first case defending the state against a big law team in Europe, in a case brought by Austrian Airlines. And when we succeeded in that case and the team realized what they could accomplish, when collaborating, engaging, willing to learn, and doing things in a little bit different way, they were thrilled. And that led to, I was thrilled as well that we prevailed in that case. And it went on to result in several other engagements, all of which we won, most of which resulted in cost awards in favor of the state. So it's those kinds of things. You have to, put yourself out there. I approached that team to see if they would be interested in engaging me as compared to the other offers they had. And I thought it was maybe a long shot, but they went for it. And that set the trajectory for a variety of further successful engagements. And I'm grateful to them as well.
Wonderful. Veronica, what's your story?
Thank you. Perhaps a few words. A word of advice that I also had from a partner in one of the firms where I worked in Paris. He said, when I left the firm, remember that you're a disputes lawyer, and disputes lawyers don't know anything, but they know that they can learn anything. And I think that's very true, and it has to remain true. And if you want to be a good disputes lawyer, we have to be on our toes and have that courage and willingness and flexibility and humility, like you rightly said. I'm approaching a new case, a new client, a new industry. I don't know how that piece of infrastructure is built, but I'm going to learn it because I want to learn it, because I have to understand it. I will have to understand the law, the field of law, so that applies in order to do a good job. And I'm not only doing disputes work, I also do advisory work from time to time, because that again, I think just makes you a better disputes lawyer, seeing SPAs again and again, and seeing facility agreements and how they come about and how deals are closed. It again just feeds in and makes you a better disputes lawyer. You know, being willing to learn and to apply that to the new cases, I think is incredibly important, and one has to keep them. But working, sorry, that was your point on SPAs and other deals. You realize how, I'm sure there are exceptions, but transactional lawyers, they do what they know and they don't go beyond that. So an M&A deal has a tax aspect. I put down the pen. I'm an M&A lawyer. M&A deal has a labor law aspect. People put down the pen, go and talk to my labor law specialist colleague. IP law, they wouldn't open the, like, even basic things. I'm not saying, they just put down the pen, and I'm not going to look at it, go and talk to the specialist. I'm only doing the M&A. And I think we don't have that as disputes lawyers, and we mustn't have that, because it's this humility and willingness to learn and ability to learn is very important to keep going. Which then, in terms of war story, again, just to say how small teams can, so it's not the size that matters, but it's the size of the fight in the dog. Like a common colleague used to say, it's not the size of the dog in the fight that matters. Last summer, I found myself in an exit hearing where we were two senior lawyers. We came into a case, it's an investor state arbitration concerning a Central Eastern European state. We're acting for the investor. We came into the case many years into the case after the investor lost for various reasons his big law representation. There were two lawyers and a trainee up against an army, and literally an army of lawyers from a traditional firm. He did a very good job, but we are still waiting for the award. But I think other than psychological warfare, if you work really hard, like we've also had, I think you can meet and respond to those arguments and do a very good job for the client. And I think the client was also very happy. So don't be impressed by the number of bodies that people tend to throw at cases and the name of the firm, because ultimately it's a good fight, and if you put in the muscle, I think results should show. Yeah.
Veronica, on your point regarding facing a number of bodies on the other side, you reminded me of a senior partner that I worked with many years ago, who once entered a hearing. He was, I think, alone with an associate, and there were 12 people on the other side of the room. And he said to the tribunal, "Well, I'm glad it's not a rugby match." And back to my war story. When I started at Core Issues, I remember it was a Friday and it was 4 p.m. and my previous firm generously unplugged me, so I stopped receiving my email at 1600. And right at the same time, I started receiving emails on my new Core Issues email address, which was just fantastic and seamless, and was one of the most satisfying professional moments in my life. I was an arbitrator in a case, so the counsel were aware that they should communicate to me to the new address, which they did, and it worked flawlessly, and that was good. And it was a Friday. So I worked over the weekends, and I must say, I didn't have a large portfolio of cases at that moment. But then on Monday, the head of the litigation team in London from Canal Gates, my previous firm, calls me and says, Pollack, we have a situation. We are just pitching to a client. It's an Australian fund. They have a dispute involving Poland. We are pitching against one of the major London firms. They also don't have an office in Poland. And, we don't have capacity in Polish law, but maybe we could co-counsel with you. And I was like, sure, I sure have no conflicts. And I will be happy to work with you, more than happy to work on this case. So he says, do you have a professional bio that you could send me? And I need it today. And I was like, no, it's literally my first working day in this operation. So actually I don't have a bio. Yeah, sure, I will send it to you in 3 hours. And I called an external graphic designer that I was working with, and I said, it's an emergency. You need to help me, and I need my, shiny new bio within 3 hours. So we put something together, largely using the layout that I had used at Canal Gates, but with a new logo, with a new photo, and my new credentials. And I submitted this, and we won that pitch, and this was an important source of my income for the next months. And that only underlines what I said before. It's the quick that beats the slow, and not the big that beats the small.
I've been thinking a good piece of advice, since it is a bit late, that if you're the last one speaking before lunch, maybe you don't wish to say the war story now. I can say it over lunch.
I'll leave that to you.
Yeah.
Well, I'll invite if there are any questions from the audience. And thank you all for sharing your war stories. I just see that there's some common theme, some like takeaways, which definitely are like be courageous, have humility, and dare. I know that dare greatly, and great things might happen. With that, do we have any questions from the audience?
Thanks very much, Veronica. My name is Parvan Parvanov. I am Bulgarian by birth, and I happen to be one of those love story warriors who crossed the Atlantic because of a wife, who was then my co-friend. So I have a quick question. I happen to be running a practice that is exclusively international arbitration out of New York. And I wanted to ask, I heard a lot of illuminating things today. And something that I wanted to hear your thoughts on is, how often do you see arbitrator bias because you're not a big law firm, and because you're not going to be able to potentially provide further appointments in the future? And if you see that, is there a particular delineating factor that you see as how much the cases for that you can point to and say, in these cases, in the smaller cases, we see no problem with that, but in the bigger ones, it seems like the big law firm and counsel from big law have some sway. Thank you.
Let me start. Unfortunately, this is something that I believe I have seen. And I don't think it depends on the size of the case, but it rather depends, I think, on certain personalities of certain arbitrators. And I would also maybe expect that to be more frequent in arbitrators who already come themselves from big law. But I'm afraid that there is some perceptible or sometimes even clear bias, especially if we are up against a big international firm that is likely to reappoint the arbiter. I have no idea how to find it. And this is something, and of course, this is not something that gives grounds to any challenge in most cases, but unfortunately, as I presume from your question, this is also something that you that you have come across.
I could just follow up on that, maybe to not to deny Wojciech's experience, but to say that maybe it's not all despair and hopelessness, because I have experienced over the years, maybe when I was more junior and appeared more junior and was sometimes maybe with a ragtag bunch of local practitioners trying to defend a case against a big team, often big US teams come with a, let's say, what could be described as sometimes an aggressive or overly aggressive approach. And if you have 3 European arbitrators, you sometimes see that they will often move to protect what they see to be the smaller fish in the pond and try to temper some of the, let's say, tactics that we all have seen and been familiar with in arbitration. So I have seen that. I'm not saying that what you asked about, what you described, does not happen, but my own experience is that the arbitrators are all trying to do their very best in an objective way, as far as I see it. So I wouldn't let that concern get you down. And also, by doing well and becoming a known quantity in the field, they'll not want to be seen to be showing favoritism to the big law firms and have a reputation of that sort. Right?
I would second that, and just to say on the bright side that I think I have come across arbitrators who are actually protecting the David against the Goliath, so there can be sympathy. It really is a matter of personality. Sometimes you only find out about the arbitrator's personality once you have them on the panel, but then there are also those who take their duties more seriously, or the duties come first, and only then their own business model and reappointments. So I've had a lot of support from arbitrators because we were a small team, because we were a new team. So we have no further questions. Just going to briefly check if we have any from our virtual attendees. No further questions. Well, with that, please join me with a round of applause for our wonderful panel. Thank you so much. I absolutely enjoyed this panel, and I hope you all did as well. And now I invite you to join us for lunch. We are running slightly behind schedule, so we will resume at 2:45 for the third session of the day, and lunch is going to be served just outside of this room. So bon appetit, and thank you very much.